My name is Garza. I'm an attorney with the Nan Gallagher Law Group. We're in North Jersey, but we represent healthcare professionals and representatives and staffs, hospitals, all along the eastern seaboard, New Jersey, New York, Massachusetts, Maryland, Pennsylvania, and a number of other states. And we're here to talk about the business of medicine today. A little bit of background before we begin on our firm, what we do. We focus on healthcare professionals like yourselves, all different types of specialties, all different things from transactional matters, various contracts, transactions that you may enter into over the life cycle of your practice, which is really what we'll be focusing on today, but also in other things, litigation, audits, for example, Medicare audits, peer review investigations, hospital investigations, medical staff, things like that. We do all of that. And today what we'll be focusing on is the business of medicine, specifically business law issues in medicine, right? So primarily these issues are from the viewpoint of the perspective of a medical practice owner. But even if you're not an owner and you look to become one, or you're a partner in a medical practice, I think what we're going to be talking about today is going to be pretty helpful for you, either whether you know some of this stuff already and it's a good rehash of some of these things to fill in some of the details, or even better, if some of these things are things that you were unaware of before just because you're too busy. Far be it for me to say, as a medical professional that you're too busy, but you've got a lot on your minds outside of just the clinical practice, right? And it seems to get more complex every day. So hopefully this presentation will give you a nice overview to be able to take care of some of your business questions, business law concerns. So what we'll be doing this morning is we'll be talking about four broad areas of this, right? So number one are and all of this, overarching all this, it really comes down to relationships, your human relationships with various people and entities that you come across in your practice. So, right off the top, we'll talk about your agreements and relationships with your vendors, service providers, right? And then we'll go into to your relationships and agreements with your employees, contractors, freelancers, business partners. You may own the practice by yourself, or you may have business partners. How about your relationship with them, right? What are some of the legal ramifications and legal things you should be thinking of to protect yourself and your partners to avoid conflict down the road? And exit planning. At some point in the life cycle of your practice, you are going to be looking at what's next, what's down the road, right? So whether you're right there or going to be there within the next few years, even earlier, or whether that's something distant on the horizon, to give you an idea of what that process typically looks like. So rather than just being kind of the light at the end of the tunnel, you actually know some of the more concrete things that are involved in that practice. And you feel like you're much more knowledgeable about it. So vendors, contracts with service providers. So when we're talking about this, we're thinking about, contracts with things like, the IT company for the practice. You may have a marketing company, helps get the name of the practice out there. Your accounting firm, your lawyers, if you have them. Anybody that you have an agreement with, typically non-medical service provider is what we're concentrating on here. Medical service provider, like electronic medical records. I mean, that's a whole separate beast. That could be a whole separate presentation, right? So kind of segregating that out, these are the types of agreements I want to talk about now, right? And so the situation where this has or could come up is I was representing a physician, and he was looking to grow his practice. and he was looking to grow past 2 offices and add a 3rd office and maybe even a 4th office within the next, definitely going to add 1 within the next year, and then looking at a 4th one within, the next 3 to 5 year time frame. And when we were talking, it was clear that he felt his current service providers, they were perfect for him now, but as far as him growing, he didn't feel that they were the right provider as he grows, as he scales. So he wanted to look for other service providers and essentially wanted to terminate these agreements, right? So he retained me to look at all of his agreements and help him, to make sure he can terminate them with the providers that he wanted to, and that he wouldn't have any problems, wouldn't have any issues. So looked at all of his agreements, and a lot of them, they were fine. They weren't too problematic, but a couple were, and one was with his IT company, and the other was with his marketing company. So his IT company, he'd wanted to terminate with them, he said, for a while. He felt they were nickel and diming him and just sending him way too many invoices instead of monthly invoices, just a host of issues, right? So he wanted to terminate that. That was an annual contract. He was paying them, I think, around $1,500 a month or so to do what they were doing for him. And when I looked at that agreement, you look at the fine print and the termination provisions. So this was problematic, right? So the termination, it was really an automatic renewal, year-over-year contract, right? And the termination the termination provisions were not specific about when and how he could terminate. It was very clear that they could terminate at any time on 30 days notice and what they would need to do, but in clearing them of any liability for that. But as far as the doctor, right, the agreement was silent on a lot of things there. So the way the contract currently read was that it appeared to read that you could not, if you were the doctor, could not cancel the contract mid-year. That only on the renewal period could you cancel that. Now, that was problematic for him because he was looking to cancel in March of that year, and if the IT company was going to look to hold him to the rest of that year, essentially as a penalty, he was looking at it around $15,000 of having to pay them there. So reached out to the IT company, and we talked about it, and they agreed to release him from the contract without holding him to that provision. Now, it took a while of my going to them and trying to get the person that I needed to get that language scaled back. But that's something where you really want, rather than sending off a termination letter or termination email and getting stuck with a bill, thousands of dollars from the company, it really pays to have that language stricken or cleared out at the outset, so you're not facing that on the back end. The marketing company, actually this wasn't for him, this was for another client of mine. They were a plastic surgery group, and they had a marketing contract, social media, local digital billboards, both in the mall and other areas of the area where they lived in, and they wanted to terminate that contract. And the reason is because they had been paying that marketing company for a few months, and they realized that marketing company was also doing the same work for a competitor a couple of towns over, marketing through the same channels, having the same competitor's office show up on these digital billboards and models in malls and things like that. So that obviously wasn't good for them. They didn't want that. But again, they'd already spent thousands of dollars, I think maybe just over $10,000 of this marketing company working for them, whereas at the beginning, if they required or mandated to try to get an exclusivity provision in that contract, for example, saying, look, we're the only practice that you're doing this work for within X mile range, that would have really helped them, because they liked the work that this marketing company was doing for them. They just didn't want want them doing it for a competitor of theirs either. So these are things that you can get handled at the outset rather than, you know, spending potentially thousands of dollars and getting months down the road and realize, hey, this provider is really not for me. So, you know, a lot of things with these contracts, I mean, when you look at it, this is, you know, I call it Contracts Review 101 and how an attorney reviews these contracts. When you look at them, there's as an attorney, I look at them and there are a lot of traps, there can be a lot of traps for the unwary in these agreements, right? It's not like reading a book, it's not like reading a magazine, any other type of reading that one would do if you want to do it well, right? A lot of times the most confusing way or the most likely to confuse way to read through a contract is to read through it sequentially, line by line, right? I mean, a lot of times I notice when I look at a contract, I won't, you know, maybe I'll read the top, who are the parties, but then immediately I'll go to the termination provisions, right? And then I'll go back and much like, you know, in that way I've heard it described more similarly as you know, writing or reading a computer program versus actually doing, you know, any kind of other reading. And I thought that analogy was pretty interesting because it's definitely a different eye that you look at it and reading it. So what does all this mean for you? Well, that means that if you're trying to read it that way, sequentially, like any other type of reading, there's a large possibility that you could just be wasting your time or spending it, you know, very inefficiently. And as busy as you are as physicians, the last thing you want to be doing is wasting your time or not spending it as efficiently you could with what you're best at. So that's really where these types of things they excel by passing them over to your experts, your attorney, ideally you're a healthcare attorney, who can look at it and give you really a Cliff's Notes or a Sparks Notes bulletin after looking at it and say, hey doctor, you know, let's schedule a quick conference call, talk about it, and I can give you the high points of this agreement, things you need to watch out for, things you need to know about, or things we need to revise, versus you spending, you know, half a Saturday morning or Sunday or whatever trying to go through the contract and figure it out for yourself. Contracts, a couple of big things to watch out for when you are reviewing them, or I know when your attorney's reviewing them. Ambiguity tends to be an issue I see quite frequently in this contract. In these contracts. So, you know, what do I mean by ambiguity? Well, when you're going through it, for example, the use of the word reasonable without further explanation. You know, reasonable expenses will be charged in connection with this service or in connection with this supplementary service. You know, we'll provide this X, Y, or Z within a reasonable period of time. We'll provide you a report or this or that within a reasonable period of time without, you know, specifying a specific period of time. And that's important because when you look at it and you're reading through the contract and you see the word reasonable, you know, I think psychologically you look at it and you think, oh, okay, that's fine. I'm reasonable and the other side's reasonable, so this, we'll be able to work this out. That may be true, but what if it's not true, right? So what may be reasonable to you could be completely unreasonable to somebody else. You know, what if your contractor or patient said, oh, I'll pay you, or the insurance company said, I'll pay you within a reasonable amount of time. It's like, what does that mean? You know, does that mean I'll get my payment in 30 days or 6 months or more? You know, so that's where it could be important. Also, another thing I see with contracts to watch out for is language within the contracts that's internally inconsistent, right? One, you know, paragraph 3 says one thing, but then you look, you know, 3 or 4 pages later, and paragraph 14 says something that conflicts with that. Well, which one of those languages, you know, what controls there? So I think that's where it's important to know, because there may be language in there in the contract that specifies which provision controls, or it may actually be inconsistent. It may not be drafted that well, to be quite honest, right? And how are you going to know that? Well, you know, from an attorney standpoint, when I look at these contracts, it's like you looking at a medical report or anything, or medical diagnosis. versus somebody that's not within your specialty. It hops off at the page to you, and that's what these things do to me, right? I read over the contract, hops out at me. I look and I'm able to tell very quickly whether it's not actually an inconsistency within the contract, or whether, you know what, this is a problem, need to go back to the other side and have them clarify what this means. And that could mean the difference in thousands, tens of thousands of dollars, like that contract I talked about earlier of the physician looking to try to terminate the contract, right? One provision says, oh, either side can terminate on 30 days notice. Okay, that looks good. That's pretty standard. But then you read elsewhere in the contract, there's a minimum 1 year, mandatory 1 year term. And then afterwards, it goes month to month. It's like, well, if you're dissatisfied with that contract 3 months, 6 months in, can you still cancel it, like the previous language said? Or do you have to serve out that year and then the 30-day cancellation applies? So it's important you want to know that, because that could be the difference between, if the vendor's willing to renegotiate that, great. If they're not, that may be the difference between you saying, Len, I like this vendor, but let's go with this other vendor because this one restricts me a little bit too much. And then also, when you're going through these contracts, really any contract, just make sure, or really your attorney, just making sure that that really the core terms are there. And the core terms are, who are the parties? We want to make sure we're clear of those. You want to make sure you're not personally the party on the contract, but your medical practice is, right? And you're signing on behalf of the medical practice. Payment terms, who pays what and when. That may sound obvious when I'm talking about it up here. It's like, yeah, Len, of course, you'd want to know that. But when you actually get into the details and looking at the contract, sometimes that may not be as clear as you might think it is. Oh, they're going to pay X amount over this term of the contract. Does that really say that? Have you had emails back and forth or phone conversations with the other side and you think you have a good understanding? But the contract, which is a form contract they use with every doctor's office, doesn't actually reflect that, right? We want to make sure that the contract reflects what the actual agreement between you and the other side is. Performance, the same thing is there. You want to be very clear. You want to make sure it's very clear what that service provider has to do for you. Why is that so important? Well, because if they're not doing it, you want to have a reason to be able to get out of the contract and not have them come back to you potentially and say, oh no, we were complying with the contract. You're still on the hook for the rest of the year or the rest of the term, whatever that is. If you have a termination, a provision that allows you to terminate the contract with very little strings attached, terminate immediately, terminate within 30 days, that's much less of an issue. But many of these contracts don't have that, at least from your standpoint. They have it from the service provider standpoint. They can terminate that quickly. But from the physician standpoint, I notice those provisions a lot of times are not mutual, and you would have to have reason to cancel the contract. So before getting to that relationship, we always try to revise that so it be equal on both sides. But if you've already signed up and you're in that contract, then it becomes very important that the services are very specifically laid out in the contract. A couple other points before we move on to employees and contractors is, when I'm talking not only to physicians, but, I have some other, and have had some other non-physician clients, tech companies. I represent startups and other mid-market companies as well. And something that I run across quite not infrequently is the belief that less is more regarding these contracts, right? It's, Len, we want to keep this short, sweet, simple. We don't want an overlong contract, 20, 30, 40 pages. It's a very straightforward agreement. We know what we want to do. We want to, keep as much legalese as we can out of it. And I understand that. I understand that on the surface. A lot of this language, probably appears to be arcane and just intractable. How do you get through it? So I definitely understand that. However, I think it's important to realize, when you get into these contracts, why is it long? Well, you don't want to have it be long for no reason, just to have, a bunch of here to, where to, for, therefores, everything like that. But saying, have a lot of words, but not really saying much. Absolutely, you don't want that. But if the reason that the agreement's long is to account for a number of contingencies that may happen between the parties and provide a roadmap for the parties, that's something that really, to protect your own interests, a lot of those provisions, more often than not, should stay in the agreement. And it's a case-by-case basis. You should talk to your attorney if you feel an agreement's overlong or has a lot of things that don't apply to that particular transaction. But many times when I talk to my clients, if they have that feeling, I explain to them some of the different situations that have arisen with other clients that I've had, or in other situations, and how different situations come up that you don't anticipate right now, but if it comes up and you have to look at the contract, you're really happy, sigh a sigh of relief that the contract actually has language guiding the parties about what they should do there, versus looking at the contract and saying, oh wow, the contract's silent, doesn't say anything about it. What do we do now? Well, right now as we go to case law, or what the statutes say, and we try to find, as an attorney, we try to find analogous situations. And some situations may come down on your side, some may come down on the other side. But what this means is it's going to be a lot harder, and you may not be able to get your way without, if the issue is important enough, without going to court or potentially suing the other side. So when you're looking at that, that's instantly a place that you don't want to be, right? So, I did litigation. It was appearing in courts, lived in courts for a number of years early in my career. And believe me, the only people most of the time in those cases, the only people that win are the lawyers, right? The litigation attorneys. I mean, it's just so much. It's not like TV or the movies where you get in and get out with a black and white decision in 60 days or even 6 months. I mean, these things tend to be, more often than not, battles of attrition. You get in there, you go in for a court appearance and you think, oh, something's really going to happen in this court appearance, right? And all it does is the judge gets in there and punts the ball on the decision for another 3 to 6 months for reasons that you can barely understand, or that the lawyers barely don't even agree with. So to actually get to a decision or a determination in court, it can many times take years, depending on the transaction or the situation that you're looking at. But if you can avoid it at all possible, most of the time it makes sense to try to negotiate and try to come out of there and cut your losses and move on to the next transaction, at least where business transactions are concerned. There's other types of litigation that's just not practical. Another thing to watch out for is using boilerplate forms. Boilerplate forms with leaving blanks as well. So I'm sure you're all aware of them. They're pre-printed boilerplate forms. You can get them everywhere. You can get them online, free or low cost online. You may be able to get them from professional societies, maybe even a colleague, any of those places. So in some cases, that may be fine. That may not be a problem. The transaction may have, to you, very little, in your estimation, importance to the practice and really not much at stake. And so you think, okay, I'm fine using this boilerplate. And, that may be the case. It depends on the situation. However, the problem with using those forms is you don't know that there's a problem until there is a problem. And many times when there is a problem, when you realize it, it's too late to do something about it. Or at least it's too late without expending a lot of money to get yourself out of that problem. So, the biggest thing with this is that these type of generic forms, they're not customized to your specific transaction, and they're not customized in the way that they need to be, right? So they're customized in that, okay, they have fill in the blanks and you fill in your name as one side of the party and you fill in the other side's party, their name in the contract, and you fill in but what the payment terms are, and you feel that those are specific enough. They may be, they may not be. But what I see happen in some of these agreements is that you fill in, or the parties fill in some of those blanks, but then some of the other blanks, they don't know how to fill those in and they just leave those blank. Hopefully that's not a problem. Could be a problem. If you're looking at that and you're looking to enforce any part of that contract, if you have to fill in, for example, a date and time frames or time limits to enforce certain actions are 30 days from that date, you can do it. Or the other side has 15 days to cure, 60 days to cure from the date mentioned in part, paragraph 2 sub 3. And you look up at, or I look up when I get retained, paragraph 2 sub 3, and there's a blank in there as far as the date, where those days are to run from. That's a problem, because I can come back to my client and say, look, we're trying to say that they delayed and they didn't provide the services that they were supposed to provide by X amount of time. That time under this contract, they can argue, never started running because this date wasn't filled in. So these are things that pop up after the fact that can be costly to try to rectify and try to fix. So moving on, when you're talking about employees and contractors, this is obviously a key, maybe one of the key relationships in agreements that you have with your practice, personnel management, and dealing with their contractual relationships. What agreements, what contractual rights do you have and do they have regarding their employment? I have a client, podiatric surgery group, just a couple of years ago, maybe not quite that, but that they came to me because they were entertaining an offer from private equity to purchase their practice group. And this private equity, one of the companies in their portfolio was buying up podiatric surgery groups in the tri-state area, and they were next on the list and was very attractive to private equity, and they were very excited about it. My clients, by the time I'd gotten involved, had already been talking to the CEO of the company through texts, emails, phone for a few weeks, and they'd already been building that relationship, and they felt really good. And it was clear to me that by the time my clients came to me, they thought, look, this deal is pretty much done. We just need to have the lawyer come in and draft up the contract and cross the T's, dot the I's, and get us to the closing table, and we're done. Then we're sailing off in the sunset, and our bank accounts are a lot happier, and we're practicing is without the headaches of running our own practice, but now we're part of this private equity group, and all looks really good. And definitely I had the intention of getting them to that point, but along the time frame that they wanted to would be a challenge for reasons I'll go into. But it was very clear that when I got on the first, the first Zoom meeting with all the parties and the CEO, that the CEO was pressing to get this whole deal closed within the next 30 days. And that was, very aggressive. I think in my mind, I thought impossible. There's no way with all kind of the loose ends, but I didn't want to scuttle everything right there with as far as the time frame, but very, very aggressive. So, my clients sent me all the documents that need to be reviewed, documents that they need to sign on as part of the deal. And one of them was, the company that they'd be signing on to that already had a number of other physician groups as members was a pretty long LLC agreement. It was around 90 pages, maybe around 100 pages with a lot of sub-provisions and things like that. Now they'd read through all this, but how close had they read through it? Who knows? But when I read through it, there were a number of things that I saw that were problematic for my clients that I wanted to make sure they knew that they'd be signing up for. And one of them was, when you sign on to this agreement, it was very clear in looking at the voting provisions, the governance provisions, that you're essentially going to have no say. You're going from running your own practice to now you're part of a larger organization. And what are your voting rights? Well, with a number of other members in the organization, a number of important things that could come up that could affect your livelihood and your value of shares in the organization. You're not going to have a say in. And why is that? It's because now when you're joining in, you're going to be minority shareholders and you're going to have one vote for every share that you have. And then you're kind of in this other picture or room with all of these other shareholders that also have votes. So why does that matter? It's like, well, when private equity, when the company is looking to admit new members, admit new practice groups, how do you have a vote in that? What if you don't want that practice group to come in, or if you have misgivings about them coming in? Can you vote against them? Yeah, you can vote against them and get overruled very quickly. It's pretty much a non-issue. So, merging with another company. Private equity, they buy this company, and yes, they love it. They're in love with the financials, the practice group makeup, everything right now. But of course, that could change next year, 5 years, who knows when, and they sell you to another entity. What's your say in that? Do you have a vote? Yeah, you have a vote, but it's a minority shareholder vote, and you're going to get overruled very quickly. So what can you do to actually have a say in the organization? So brought this up to my client, and that was troubling to them to learn just how little say that they had. Another big thing with another big problem with the transaction was the employment agreement that the private equity company was going to require them to sign upon signing up. It had a very onerous non-compete and restrictive covenant provision. So, we were looking in, the private equity company wants these physicians, this one wanted them to come in, and they wanted to hold on to them, and they wanted there to be very steep penalties for the physicians if they ever looked to leave, and if they did look to leave, they'd want it to be so penalizing in the contractual language that it would be an immediate deterrent, and essentially you're signed up there for not for life, but for better or for worse. You're in it with them, and you don't have any say about getting out. And remember, this particular non-compete, it's actually one of the more onerous ones that I've come across in my career. The restriction was that the physicians could not leave to practice medicine anywhere, hospital, staff, anywhere within the tri-state area, and they could get out of that, couldn't go back to private practice. Now, they could get out of that, if you want to quote, get out of that, by essentially paying a penalty of 1 full year of salary and other tens of thousands of dollars of penalty fees. That's how private equity allowed them to buy out of it. So I explained this to my client. And they said, oh no, we've talked to the CEO and have emails. He sent us emails that, we're not going to be held to that. We actually can go out and continue our own private practice if it doesn't work out. And I said, okay, but that's not reflected anywhere in this agreement. It's like, okay, but yeah, we have this email. Well, let me forward you to the email. He sent me this. It's like, okay, that's great. They're going to need to revise this so it's reflected in the agreement, because you sign this agreement as is, and those emails aren't going to matter at all in court. That's contract law, basically all around the nation. So it took a lot of going back and forth with private equity to get the right language within these agreements that would actually protect my clients in line with the emails that they'd exchanged. But that's key. That's key to know. Regardless of whatever communications or emails have gone back and forth, we call it in contract and business law the four corners of the contract. If it's not within that contract, it didn't happen, right? And if this ever has to go to court or ever has to be enforced, and you're trying to seek to enforce those emails that occurred prior to the contract, you're going to have a very difficult time trying to get those in and trying to get the court to consider those. So any agreements that you have with the other side, you want to make sure that the final agreement reflects that. So we finally got the employment agreement to reflect that. But needless to say, that eventually closed. It closed 4 months later, but it did not close within the 30 days that the private equity CEO wanted it to. And to me, it was very clear that this was his MO in trying to close with these practice groups. Hey, get all these documents, these voluminous documents, in front of these practice groups as fast as possible. Get them to sign with minimal, if any, attorney review or help. Push, get them in, get them the big payout, and then once they're in the organization, you're locked in. And you basically have little to no voting rights. That was at least with this private equity. I don't want to paint a broad brush as to all private equity entities, but you need to be careful when looking at these, and you need to get counsel that has worked on these deals, M&A counsel, M&A healthcare counsel specifically, that's worked on these deals and knows what to look for, because the CEO was telling my clients, left and right, that these onerous terms that they were signing up for, this is standard in the industry. We've had so many other doctors groups that have signed up for us. They're all happy. We've never had a problem. And of course, he's a very smooth talker. So, of course, the problem with that language is, yeah, you've never had a problem until you have a problem. And when you have a problem, then what do you do, right? And maybe another reason that they've quote unquote never had a problem is because the employment the language in these contracts are so restrictive that it dissuades any doctors from coming up, any of the member doctors from coming up and giving them a problem, because they have no contractual rights to do so. So anyway, I could go on and on about that one, but needless to say, it's very important to look before you leap with these with any of these agreements, and make sure that you have the right advice and counsel going in to protect your interest. So employee contracts. So that the onerous non-compete provision on the employee contracts, that's something that you want to watch out for, and I'll get how you can look at those when you're the practice owner in a little bit. But a big thing, not only with the employee contracts, but with any contracts, are reliance on the actual four corners of the document you sign versus anything else, through oral conversations, verbal assurances, everything. And the danger with relying on any of those things versus, what the contract says is that contracts generally, and especially healthcare legal compliance, is incredibly complex. And a lot of the healthcare regulations there, when you look into it, Stark law, anti-kickback law, both on the federal, False Claims Act, both on the federal and state level. States all have their own laws regarding these things that may or may not some of them be preempted or overruled by the federal law. So really it can be this Byzantine maze of healthcare compliance laws, and a lot of those laws, when you read them, they defy common sense regarding the actual public policy behind some of these provisions. I mean, some of these provisions may seem to be at odds with short-term business goals. And certain types of contracts, the way they're worded in compensation, when we're talking about non-healthcare deals that I also work on, would be great, fantastic business deals. But then you transfer those into the healthcare context with the healthcare regulations, and some of those compensation terms would be illegal in healthcare, as I'm sure you know as well. So very important to have an eye on those when you're looking at these, and to be aware of any phrases if they come from the other side, like the CEO. Things like, oh, don't pay attention to that in the contract. That's just there to satisfy the lawyers. Or oh, that language, that doesn't apply to you. Upper management says it has to be in the contract. Don't worry about it. We'll get it taken care of. Well, never rely on those statements, right? So there's a couple of reasons why. Is that under federal healthcare regulations, Stark and anti-kickback law, depending on the type of transaction, it has to be in writing under the safe harbors of those acts, right? So not only does it make it less likely to be enforceable if it's only an oral agreement versus a written agreement, but if it's not in writing, it actually may be illegal under certain healthcare regulations. So that's very important to make sure your terms are outlined very explicitly in written agreements, and that there are no side deals outside of what's in those agreements. And also outside of that, if it's not written in the agreement, how are you going to enforce that down the road? Now, the person that told you, oh, don't worry about it, upper management will get it taken care of, that doesn't apply to you, they may be a perfectly honest and trustworthy person, but things change, organizations change. That person may leave for another job or be laid off, fired, you never know. And then for example, if you're dealing, with hospital personnel on a hospital or a directorship contract negotiations, these are some of the things I hear from time to time. If that person telling you this is no longer there, what's their successor going to do? Is their successor going to, honor the written contract, or are they going to honor, this kind of side deal or assurance that this person made to you that certain provisions wouldn't apply to you? Probably not. And in actuality, the successor would be legally obligated to not honor any of those side deals or verbal assurances, but to strictly adhere to and honor the written contract. So again, all the more important, any agreement that you have with the other side, make sure it's actually reflected in the contract and not just side discussions, texts, or side emails. So as far as your own employees in your own practice, two key distinctions when you have your own employees, what are they? W-2, 1099, these are important because obviously W-2, you have an employment agreement, you may have paid benefits for them, and then you're responsible for withholding the taxes, which again, you may have a payroll company, probably have a payroll company that you deal with that helps you with that. In contrast, if they're a contractor, freelancer, 1099, they go by a number of different names, but they're an independent contractor. They're not an actual employee under the IRS and labor code with your practice, and they're responsible for paying their own taxes. You don't withhold those taxes, and typically for them there are no paid benefits, but of course there are always things you can work out if that's part of your agreement and bringing them along. So these are just some of the things, when you're looking at with your employees or contractors. A thing that I see come up quite frequently with employees as contractors when you're talking about the practice is the allocation of off hours and on-call duty, right? So it's important to be clear with your employees when you bring them on about any on-call duty and what's required of them. A lot of times they may come in and be expecting on-call duty to be shared equally. Everybody pulls the same weight, right? But the reason that you're bringing them on, that theory may defeat the purpose of why you're bringing them on. Maybe you're doing too much on-call duty, and the whole reason, one of the main reasons you're looking at bringing on an associate physician is to help take more of that weight so you can do what you need to do to spend more time managing and running your practice and also growing your practice as well, right? So you don't have as much time, or maybe you're more senior, more mature in your career, and you want to be freed of a lot of those on-call burdens and pass those on to a younger physician. That's fine. Just make sure that in your discussions and in the agreement you're clear about that, because that helps when they join on. If they see that everything is not in fact shared equally as far as on-call, that helps soften the blow of that and avoid any potential disputes or ill feelings regarding that. So compensation, it's important to be clear about that. Compensation is obviously the number one, if not very, very, very close to the top issue in these agreements. But it's important to realize that the compensation is not just about money, but it's about more. It's about broader. The overall balance of what they're being asked to do as a member in the practice. So, when you're talking about bonus compensation, it's important to stay away from vague statements. Try to use a formula or give specific numbers where possible if you can. So for example, language like bonuses may be granted at sole discretion of the employer. Try to stay away from that language, because as an employee, potential employee, you're looking at, it may seem like the bonus is illusory, and at the discretion of the employer, that means I'll never get a bonus, right? So you want to try to give a little bit more specifics regarding bonus. Even better if you're able to tie that criteria within the agreement to specific revenue goals. Net revenue, gross revenue, expenses, revenue attributable to that specific employee. If you can tie it to those type of parameters, that's great. And if that's practical to do so, and you run that through your attorney as well, to make sure that passes legal muster, that's always great too. That looks good to employees. Fringe benefits and compensation. Obviously, this is part of the overall compensation package. If you run that, if you have the fringe benefits, you want to make clear in the agreement that these are provided at the practices, at your sole discretion, and that you can modify these or remove them at any time. And that language is important because, as great as these fringe benefits are, vacation, PTO, auto allowance, medical, dental, retirement, matching, profit share, whatever it is, those are all great things to be able to offer to employees. At the same time, as we all know, those significantly add to overhead, right? And depending on economic circumstances of the practice and the overall economy, it may be very difficult to continue offering certain things, or at least offering those at the level that the practice had been offering them, and you want to have the leeway as a practice to be able to trim back some of those things if you need to for the health of the overall practice, and to not have the employee be able to point back to the contract and say, no, these are mandated, I get these at the same level, for X amount of years or X amount of time. Growth potential with the practice is another area I wanted to touch on, specifically promising partnership. So in essence, you never want to do that. You really want to avoid that up front, no matter how much you may like the physician coming on, unless they're coming on already as a partner. But if it's an employee, a physician associate that you think really has great potential and could be in line for partnership later on, be very kind of guarded, at least in initial discussions, about how you convey that. Not every physician aspires to be a partner in a practice, but if you do, those that do, naturally they would like some type of an assurance that they're on the right track and to know kind of when that might come about. Nonetheless, regardless of all that, you want to avoid promising or guaranteeing partnership, definitely not in the employee agreement. And you want to have language in there specifically stating that this agreement for employment does not constitute an offer or promise of partnership. And this language tends to be, when I look over it or physicians look over it in the agreement, towards the end of the agreement, very easy to lump it in. It's boilerplate, but it is very important language to have in there in case that relationship down the line goes sideways and the employee physician makes allegations that, no, I was promised partnership here, and look, it even says in my employment agreement, or there's nothing in my employment agreement, contradicting that. So, way to stay out of liability there on that end as well. Right. What I'd like to do is skip forward a bit and talk about relationships with partners. Right. So why take on a partner? Right. You may have partners already. You may be practicing on your own, looking at taking on a partner in the future. Well, typical reasons for taking on a partner is they have strengths that you lack, or vice versa. A lot of times partners feel that the partnership promotes greater creativity and a way to break free of their own ways and coordinate and talk with partners and work together to find a way of practicing together that benefits everybody in the practice, right? The whole is greater than the sum of its parts is a common feeling that many partnerships, many good partnerships have. They can also help you be able to take greater risks, or maybe if you're more on the risk-taking side, help restrain you. Your partners can help restrain you from taking on too big of risks. So it's that balance, that checks and balances that can help with a partnership as well. So when your business partners are thinking about teaming up, what should you be thinking about, right? So what are your motivations for joining on as a partner, right? And a lot of times, I say it's important to have an agreement with your partner, a written agreement with your partner or partners, not just do it on a handshake deal, because the best partnerships have a deep level of trust. You even think, a marriage relationship, it's much like that in a business setting, right? So there's a deep level of trust, awareness of the other person's goals and values, and you're involved in building something together for the long term, right? And then much like personal relationships, partnerships, the worst ones, there's distrust, there's disconnect between you and your partners. The partners don't really know how the others view the venture, right? So it's very important to know the motivations that you're going in. How are you dividing the interests, the equity, right? So I work with physician practices often with the physician buy-ins and buyouts, right? So senior doctors with buyouts, they want buyouts of the practice, or maybe a junior doctor coming in looking to buy into a more senior doctor's practice. So So it's important to make sure you get the equity split right in getting into that. It's important, for example, if you're a senior doctor having the junior come in, the junior doesn't automatically, assuming you're a situation where it's just you and you're bringing on another, from the day one they step on, the way most of the time to structure it is not that it's 50-50 from day one. You want the junior partner to earn in to the partnership, and there are various ways to structure how that gets done, but having that done very similar to a stock option in a non-healthcare setting is you want that equity buy-in to motivate the associate to stay with and grow the practice over time, over a time horizon, 3, 5, 7 years, whatever it is. And also that junior associate's got to be able to finance that. And how does that get financed? Many times you may be able to get outside financing, you may not. That may have to be financed by the practice itself. There's a number of different ways to slice this orange, right? But getting the equity split right and having on a buy-in and how that's structured can mean everything is regarding to motivating that associate in the right way, rather than a year or two thinking, oh, this is not right for me, I'm looking to bolt the practice, and having to be a very onerous and expensive buyout situation for the senior doctor. All right, I see that we're pretty close right up on time here. So what I want to do is I want to go ahead and skip to the end and talk about exit, a little bit about exiting the practice, exit plan. So you could be exiting the practice for a number of reasons, whether it's now or something you're thinking about in the future, right? So it could be retirement, could be relocating to another city or state, or any number of reasons. You get like the private equity offer earlier. Sometimes, as a practice, you get an offer you feel you can't refuse, right? So there's a number of different ways this could happen. It's important when you do this, you want to get the proper advisors involved in the process as early as possible to be able to give you the best chance of accomplishing two twin goals, right, in selling your practice. So one, obviously, is maximum profit within the healthcare regulations and rules, and the other is to minimize your post-sale liabilities, right? So to make sure that when you sell your practice, that there are not going to be any lingering liabilities, lawsuits or claims that can come down the line that you're not going to have the wherewithal to pay. So, see, we've run up on time. I obviously have, a lot more to talk about with this. I'm very passionate about everything related to, transactions and negotiating and structuring these things and helping you, build, grow your practice and, eventually exit the practice gracefully and profitably. So it's something I'm very passionate about, get excited about, and kind of get carried away, as you may be able to tell. But I'd be more than happy to talk to any of you after any of this. After we talk, I'll go ahead and leave my information for you here. If there's any questions you have about anything I brought up today, please email me. Please email me, reach out, just mention you were an attendee at this conference, and I'd be happy to talk to you, help you out in any way I can. I'd like to thank you all for attending this morning. Please consider me and the firm, Nan Gallagher Law Group, as a resource for you if you have any questions on any of the things we've talked about. And thanks again for showing up. I appreciate it.